Hi, my name is Jason Leahy, Executive Director of the Illinois Principals Association, and it's my pleasure to have you join us for this edition of IPA Talk, which is a new feature here for us at the association. We just talk about different issues. We'll have various guests throughout the course of the year, however long this series runs. I guess we'll see how our ratings go with everything. But most importantly, we want to make sure to keep you, the member, up to speed on some critical issues. And for this edition, I've got with me Deputy Director and General Counsel Brian Schwartz, as well as Alison, Maley, who's our Government Public Relations Director. Thanks, both of you, for making a long trip across the hallway to my office so that we could talk about some different things like that going on.
Our pleasure.
All right, so we got a couple of key things that are already in the hopper here with the start of school. Brian, SB 100, we know, is on everybody's mind. We've provided a lot of training for this over the last several months here in the association. We've done a lot of updates to the Model Student Handbook, and now it's time for the rubber to meet the road and get busy implementing the new law. So you just want to talk about things that maybe some members need to make sure they're aware of and thinking about.
Sure, and I think everyone at this point has probably heard of Senate Bill 100, and of course it's the bill that's going to, now the law that's going to change the way that we use exclusionary discipline in schools. And anytime that we remove a child, of course, we're going to have to show that that child's continued presence at school would be some sort of disruption or safety concern. And I think that's something our members struggle with, is how do you show that someone's continued presence at school is a safety concern or a disruption? And the tack that we take is there are some offenses that are so serious, like drugs or weapons, that justifies the finding that that child's continued presence at school is a disruption. What we're worried about is those lesser offenses where you're really going to have to look at the child's past history related to that type of offense, and then make the decision whether or not exclusionary discipline or something else is more appropriate. And it will take a couple of court cases to finally flesh this whole thing out in terms of what is and what is not appropriate. The one thing that we insisted on with the legislation, now the law, is that school officials get to make that underlying decision, what it means to be a disruption or a safety concern. And in implementing this and in looking at that student who's committed an infraction that justifies exclusionary discipline, that's important that school officials are the ones that get to make that call. And what I've noticed over the years is that courts really don't like to step into the shoes of school officials. They only really will overturn a school official's judgment if the procedure wasn't followed or it's so clearly erroneous that the court has no choice. So what we'd like to tell our members certainly is work with your school district's counsel, especially for the first time that you look at exclusionary discipline this year. But make sure that you follow the rules, use the forms that the Alliance and the IPA has put out, and make sure that you're able to articulate and document that disruption or that safety concern. And I think as long as those two things are done, if mom and dad were to challenge, a court's going to give the school official great deference.
Yeah. So, Brian, one of the things with the law that they talk about is schools making every attempt to keep kids in school, obviously, and then we know that there's also got to be reentry planning and those kinds of things for students. You got any thoughts on that schools, how they need to be working with that internally, maybe other organizations or other groups outside of schools they can be working with on some of this stuff? You got any thoughts on those things?
Sure. And I think as we have now dealt with Senate Bill 100 a little bit and talked about it, we've developed a greater comfort level with it. And I think that it's not exactly articulately written. It's not a perfect piece of legislation, but it's going to be good for kids. Because not only does it look at alternatives to exclusionary discipline, but then when a child comes back from exclusion, you have to make sure that we let them know that they have the right to make up their work. They sit down with their administrator, their teachers, whoever the case may be, to make sure that they're then at the point where they can be successful in the future.
Very good. All right, so let's turn a little bit from state matters to federal matters. Alison, you've been working quite a bit with the state board's stakeholder group that's been looking at ESSA reauthorization. We know that that's in play. We've got a plan. Now we got a draft plan apparently on the table with regards to ESSA for the state of Illinois. So do you mind just talking a little bit about your work with that and kind of what's going on right now?
Sure. So really what we've been doing is ISB has put together a stakeholder group, work groups. We've been meeting since early July, almost every other week, about the accountability part of ESSA's plan, or the Illinois plan for ESSA. So we've been talking about things like long-term and interim goals for student achievement, in various indicators that we want to have for academic and academic progress and graduation rates, those types of things. English learner proficiency, all these things that are going to go into the accountability system that Illinois will use for ESSA and for our accountability for the state as well. So, of course, our colleagues with the Alliance have been involved in the balanced accountability measure. So a lot of that work is sort of interchangeable with what we've been doing with the state board. The draft plan is out, so you can access that on ISB's website.
Good nighttime reading for somebody.
Right, it's about 100 pages.
Sure.
So it's available, and then they will be taking comments on that up until September 30th, of course, next month. But they will also be doing a second round of listening tours. So those begin September 6th, beginning at Freeport High School, and continue through the month, so people can react to the draft that's been put forward so far.
So, Alison, do you mind sharing, we don't have to get into too much detail because individuals can go and look at the plan for themselves, but do you mind talking a little bit about some of the indicators that you guys have been talking about during these working groups and what folks might expect when they read the plan?
Sure. So there are indicators that are required by law. Academic performance indicators and graduation rates is one of them. So those are the things that we do have to include in the plan per the statute that the federal government had put forward. But we've also been looking at things like school climate, parental involvement, pre-K and high school indicators, access to classes like AP and International Baccalaureate, those types of things. What are the kind of college readiness accessibility measures are there? Those types of things we've been looking at as far as indicators beyond what the law requires.
Very good. Very good. So please be sure to get to the ISB's website,
Yes.
download that and react to that, add feedback, give comments, and then if there are any questions, obviously contact us here and talk a little bit about that. Yep. One last thing, Brian, I want to talk about here before we cut away. Transgender students, we had a recent decision from a judge, a pretty big one, with regards to transgender students, and thought it might be important to touch on this. I know that you've been sharing information out in your Legally Speaking every month, but since we've got some time here, thought maybe you could speak to that briefly.
Sure, and probably in the 18 years that I've been here, probably the most contentious issue that I remember dealing with, contentious on both sides. You've got the Obama administration and a federal appellate court saying that kids should be allowed to use whatever bathroom is consistent with their gender identity. Then you've got the United States Supreme Court that put the federal court on hold, and then you've got a bunch of lower courts that are just all over the board. So this is one that's going to take a while to shake out, and we're going to need some guidance from the courts to determine exactly where we should be in terms of accommodating transgender kids.
So where are we right now?
Well, right now, I think there are some easy things that we can do to accommodate every child, and in particular transgender children, to make sure that they feel protected and they feel that they're valued, and that is to meet with the kids, meet with their parents, find out what their needs are. I think there are some easy things that we can do, like using a name or pronoun consistent with their gender identity. But when it comes to those tougher decisions like restroom use and locker room, that's not the building principal's decision. That's something that the board should decide, and then the building principal should implement the board's decision.
Very good.
And those are the ones that are legally contentious right now.
Absolutely. And of course, if folks continue to have questions about that, they need to contact you, or more importantly, contact their legal counsel in their school district, work with their superintendent and their boards on these issues. Very good. Very good. Well, thanks for joining us for this edition of IPA Talk. Brian and Alison, thanks for sitting in and taking time out of your busy day. My name is Jason Leahy, Executive Director of the Illinois Principals Association. As always, if there's anything we can do for you at any time, call us here at the office or check us out on the web at www.ilprincipals.org. Take care.